So what is critical thinking? I'm Richard Pennington. I'm an NIGP member. I was formerly general counsel to NASPO Value Point, and I'm retired now from the practice of law. 14 years ago, I also did my share of critical thinking when I was the Colorado State Procurement Director. We're going to spend some time talking about critical thinking. You know, in the NIGP Pathways program, they adopt a public procurement competency model that has as one of the competencies critical thinking. They embed critical thinking in all of the certificates. You'll get a chance to practice. One thing I've learned is that there are lots of definitions for critical thinking. One of the best I found was from a slide on the University of Tennessee website. Critical thinking involves asking questions, defining the problem, examining evidence, analyzing assumptions and biases, avoiding emotional reasoning, avoiding oversimplification, considering other interpretations, and tolerating ambiguity. That's about as comprehensive a definition as I've ever seen, and actually a good checklist for you as you listen to this video and then in the future practice critical thinking on your own and with your team. I'm going to tell you a story that illustrates the application of critical thinking to both the practice of law, in this case litigation, and also the decisions that purchasing agents make. 20 years ago, I was an attorney in the Colorado Attorney General's office, and one of our clients was the Department of Corrections. Corrections was always either building new prisons or maintaining the existing ones, and in this case in particular, they were installing a new power plant with the steam distribution lines that ran from the plant to the facility. It required a great amount of welding of sections of fairly large piping. One day, a corrections officer who happened to have some personal experience with welding happened to be outside watching from a distance and thought he saw some welding practices that were shortcuts. He reported that up the department, and they looked at it and decided they needed to exercise contract remedies to have a section or several sections of the piping removed so they could perform x-rays on the welds. Now, I learned more about welding, as this slide indicates, than I ever hoped to. This slide shows a series of defective welds, including one that's good for comparison, and some of the reasons that lead to that. And the actual procedures that are used by the welders are very important to achieving good sound welds. And in fact, the welding specification, the American Society of Mechanical Engineers specification, uses a welding procedure process to define how the welders weld that's submitted by the contractor, consistent with the specification and approved by the department. Well, in this case, when the radiography results came back, it was pretty clear to the department that these welds really were bad. They rejected the work, ordered the welds torn out, the welding reperformed, and the procedure used going forward consistent with what had been approved. The contractor wasn't happy, obviously, and they submitted what's known as a constructive change claim, meaning they thought that the work that they were required to do they had bid on, and that was what was being directed now by the department, was extra work, not contractually required. That claim was denied by the department. Then the contractor filed a suit in the amount of $600,000 in local district court, and I was brought in to defend. What we're going to do then is apply the tips you just learned to not only the litigation decisions that we were having to make as a trial team, but also the procurement decisions that the purchasing agent had made a couple years before. Ask yourselves as you listen to this, how does this compare with the types of things that I do when I'm trying to analyze information and critically think about the decisions I have to make in procurement? First, formulate the question. We as a litigation team had an early decision to make, probably 3 weeks after we completed the complaint and answer pleading process. The decision was whether we would have to or want to request a jury trial or judge alone trial. And you know, as questions go, there's a couple subsidiary questions usually. One was, what's the law? I mean, the second question is, can we ever make a jury understand the welding specification in the American Society of Mechanical Engineering specification and the elements of constructive change under the law? So flash back a little bit to the sourcing decision that was made by the purchasing agent. She no doubt had lots of decisions, but one of those was whether she'd use an IFB, invitation for bid, or a request for proposal, an RFP. One question was, did she have authority? And the answer in Colorado happened to be yes. She could do an RFP. But the other question was, were the specifications certain enough and the scope of work otherwise certain enough so that a supplier could actually bid? Tip 2, gather the information. Attorneys use a process called discovery, and that usually involves depositions, interrogatories, document productions, things that we hadn't gotten to yet when we had to make the decision a few weeks in. We used the available information, the project records, talk to the architect engineer, the construction manager that the Department of Corrections used for these kinds of projects. As I recall, we even talked to the employee that had first started the issue by his observations. Of course, we read the contract and the specifications in order to make these decisions about whether to go to a jury or a judge. Again, flashback 2 years prior, and there was a binary choice being made, among others, by the purchasing agent. What kind of information did she need? Well, as it turned out, she had never done one of these before. So she was gathering information from the architect engineer team, the construction manager that had a lot of experience. She went to market research. That's one of your key areas, to go to them and find out, you know, have you done this kind of work before? Who's done a good solicitation that you thought was a decent solicitation that we might look at? What's the industry practices in this regard in terms of this sort of work, IFB or RFP? Gather that information. She probably went on the internet. And I'll bet she might have gone to the NIGP community and asked if anyone else had ever done one of these before and if they could send her a solicitation. Gather the information. Then apply the information. That's probably the hardest part. This is where you take your information, assess the credibility, look at assumptions and biases, try to figure out as close as you can to what the truth is, and then fit that into your model. In attorneys, we have a litigation model that we use. You know, ultimately, we're taught you're trying to get to the end to tell a story that will be adopted by the fact finder, either the judge or the jury, consistent with what your theory of the case is. But there's analysis that needs to be done, including the law of constructive change and how complex that is. And once I opened up the specification, it was pretty clear to me this was hard. The purchasing agent had a lot of application too. I mean, luckily, and NIGP has some nice models that they teach for the differences between IFPs and RFPs and which one is suitable for which sorts of things. And you get pretty quickly to the second question in that analysis, which is, is this really a specific enough statement of work, clear enough that you can expect suppliers to bid low price? You know, there's this biases here, because if you went to market research meetings or had some RFI and you get information, there's probably going to be a little bit of nudging in terms of the submissions, in terms of their strengths. And you've got to understand that. There's probably assumptions too. Here's the biggest one. If you get a solicitation from a colleague, are you assuming that it's current and that specifications haven't changed? It's a good roadmap, but probably not one that you can rely on. Apply the information. Tip 4, consider the implications. If we had chosen a jury, which we ultimately didn't, what would have happened would have been the trial probably would have been delayed longer than with the judge alone trial. And the trial duration would have been longer. And we risked maybe not even having witnesses available. You know, sometimes witnesses die in the intervening time. And at the very least, you have problems with memory. On the procurement side, there's similar implications. If you choose an IFB, it's short, but there's no opportunity really, except for minor informalities, for much of an information exchange. And you've read the stories, people making fun of the low bid awards. You're ultimately going to make a bid or an award based on a low price. RFP has its own implications. Yes, there's a chance for information exchange, clarification of requirements, even proposal revisions, but it takes time. You may not be able to afford the time. It also takes resources. RFPs tend to be much more resource intensive. So consider the implications. Fifth, consider other points of view. On our litigation team, as we moved down through discovery, we hired experts. And so at every stage, we were trying to assess what our litigation risk was, whether we should make a settlement offer. And ultimately, we actually did for about 60 or 80,000. I had co-counsel to help me every step of the way. We had a great paralegal. And so we could bounce ideas off each other in terms of the decisions we were made. You know that ambiguity piece that was in the University of Tennessee? These sorts of collaborations really help you benchmark that. You talk as a team. And if you flash back 2 years to the purchasing agent's decision, she was surrounded by a team too. You know, many of you have users in using organizations that submit the requisitions that can be really a source to bounce ideas off of. She had a great architect engineer team, a first-rate construction management team, and of course the department that she briefed about the decisions that were being made and the reasons for them. The vendors in some measure are a part of the team. When you do market research, when you go to them and say, I'm thinking about an RFP, and their eyes roll back in the back of their heads, because they may say to you, you know, we just don't, this industry just doesn't do it that way, not for this sort of mechanical work. Consider other points of view. This is just an introduction to apply what is really a great model for critical thinking. You know, the idea here was not to assess whether we won or lost in the case. We won. Or whether the purchasing agent made the right decision. She did. Now, the point here is the process of getting to decisions and the way that you identify the questions, assemble the information, analyze it, consider implications, and as a team, look at the ambiguity. And the Pathways program is being constructed in a way that you are going to get to practice all along the way critical thinking skills. I encourage you to practice, use these opportunities.